Hello, welcome to my YouTube channel, the channel that is erased from the digital town square, because the information provided here is true and accurate. The information provided here is not based upon illogical assumptions, irrational understanding, or a product of grade 2 reasoning, like many other channels on YouTube, which are patterned after stupidity. On this channel, you will not find false premises based upon illogical reasoning, nor will you be exposed to conclusions that are created magically by false presumptions. What I share here is based strictly upon the rule of law and the principles of justice. So if you're looking for some straw man arguments that agree with your own position and assumptions about the government that sound appealing to you, because your own reasoning is stunted due to what you feed your mind, I suggest you move on and go on your way. If you think the Constitution Act of Canada is not operable because some idiot on YouTube told you so, have fun. If you think that declaring yourself a man or woman is all you need to do and you will have freedom like you have never known because some fool made a video and uploaded it to YouTube and now you're buying his crock of shit. The door is that way. Do not let it hit you on your beep beep as you exit. If you drink alcohol and take drugs often, then this channel is definitely not for you. This channel is for those who are strong in mind and rational in their thinking. It is for those who can reason above a grade 5 standard. This world and the societies therein are all operating under the control of very powerful forces that remain in function by simply keeping your intelligence below par. It is a seasoned plan meant on keeping you and all those around you in bondage to false operations of law, which limit and abridge your natural rights, your right to be free. Here in Canada, the judiciary has already declared that Canada will apply its laws against you personally, only subject to the Charter. That statement is imperative, not suggestive. It means nothing you attempt to do, nothing that you file, and nothing you declare will grant you the freedom you are searching for if you build your stance outside the Charter. Canada will apply the enactments and regulations against us only subject to the Charter Medes versus Medes. A claim that the relationship between an individual and the state is always one of contract is clearly incorrect. Aspects of that relationship may flow from mutual contract. For example, a person or corporation may be hired by the government to perform a task such as road maintenance, but the state has the right to engage in unilateral action, subject to the Charter. Okay, so now you have a choice to make. Will you listen to a straw man argument put forth by some dumb ash pretending to know what he is talking about while he contradicts the rule of law with every irrational word he or she speaks, or will you wake up to the rule of law? Now for you content creators who are deceiving men and women by telling them otherwise, for you who are telling individuals that common law is the all-powerful key you are searching for, the courts have a word for you. The Supreme Court has made it clear in cases in M.A. v. Ryan, 1997, that the common law must develop in accordance with charter values. A trespass in common law equals an infringement or denial of a fundamental right or freedom listed in the Constitution Act or the covenants themselves. Common law is true and it is real. However, common law now develops in accordance with the Charter. Common law is flowing through and in the Charter. Anyone who tells you otherwise is a liar, is confused themselves, or is just plain stupid in their understanding. Despite what I just shared with you, which as you saw was backed up by the word of the court, some people who just listen to it will deny what was brought forth, will try to find an irrational and illogical excuse in order to convince themselves that what was said is not the correct standing because it contradicts what they believe and what they have been attempting to do in order to gain freedom. Rather than adjust to the rule of law, they will now take the door, beep beep, and go find another video on YouTube which is created by a fool that will have the effect of enforcing their irrational position. Few glad Billy Bob agrees with me and I with him. Well, Billy Bob and his teachings are going to get you in trouble, because Billy Bob is a fraud and a liar, and he is selling you snake oil, just like they used to do in the early 1900s. Please do not forget to close the door on your way out. Beep, beep. This is for every fool on YouTube who has irrationally and illogically declared that the ICCPR has nothing to do with a man or woman. ICCPR Article 3. The states parties to the present covenant undertake to ensure the equal right of men and women to the enjoyment of all civil and political rights set forth in the present covenant. Oh, wow. Would you look at that, Billy Bob? The ICCPR actually brings forth the subject or player of men and women, contrary to what you have been illogically telling your followers. So your uninformed lies, which have been stating that the ICCPR does not help a man or woman or recognize a man or woman, has just been destroyed by the rule of law itself. You see, that is the power of the rule of law. It defends itself from evil people. It defends itself against liars and individuals attempting to destroy its principles, whether these individuals are private or government agents. You can never fight the rule of law. It's impossible. As you just heard, the rule of law declares to us all that it recognizes men and women, and it guarantees all the rights brought for in the covenant to you personally. Oh no, here comes Billy Bob again. What is that, Billy? You say that the ICCPR does not recognize common law rights at all. You say that inalienable rights are not protected in the ICCPR. Hey, Billy Bob, I doubt you can even recognize what an inalienable right is, unless it states directly, I am an inalienable right. The preamble of the ICCPR will speak to your illogical assumptions, considering that, in accordance with the principles proclaimed in the Charter of the United Nations, recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. Wow, will you look at that? The rule of law just declared that men and women have inalienable rights. So the rule of law just took down your false teaching, just spilled out your snake oil. But I am sure Billy Bob is too far gone to understand this simple and logical premise. Men and women have inalienable rights, and these rights are recognized and protected under the international order. If the country you live in is not respecting this truth, well, it is not the international order's fault. It's the fault of the evil people sitting in positions of authority, which are making decisions to fight and deny the rule of law, which I would say is a dangerous game to play. So common law rights must flow through the Charter and through international law, and common law rights are indeed enshrined within the ICCPR. Hey, Billy, where you going? Beep, beep. DRR Article 18.3. Individuals, groups, institutions, and non-governmental organizations also have an important role and a responsibility in contributing as appropriate to the promotion of the right of everyone to a social and international order in which the rights and freedoms set forth in the Universal Declaration of Human Rights and other human rights instruments can be fully realized. This international order is not an option or mere suggestion, but an order which produces obligations and requires due diligence to honor and fulfill. It places a duty on the government to not take actions against the rule of law, to not take actions aimed at the destruction of human rights, including non-derogable rights, which are known to most people as inalienable rights. ICCPR Article 5.1. Nothing in the present covenant may be interpreted as implying for any state, group, or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms recognized herein, or at their limitation to a greater extent than is provided for in the present covenant. ICCPR Article 2. 1. Each state party to the present covenant undertakes to respect and to ensure to all individuals within its territory and subject to its jurisdiction the rights recognized in the present covenant. 2. Where not already provided for by existing legislative or other measures, each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional processes and with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. Well, there you have it. The rule of law has declared to the agents of domestic governments that these inalienable rights are to be respected and ensured, not limited and abridged. So, Billy, do not blame the international order for something it is not guilty of doing. In Canada, this international order must be respected, for Canada is indeed a state party member who has ratified their obligations under international law. Canada is also aware of their obligation to the rule of law, particularly as it pertains to absolute, non-derogable rights, Emergencies Act, and whereas the governor and council, in taking such special temporary measures, would be subject to the Canadian Charter of Rights and Freedoms and the Canadian Bill of Rights, and must have regard to the International Covenant on Civil and Political Rights, particularly with respect to those fundamental rights that are not to be limited or abridged, even in a national emergency. So there it is, clear as day. Can you see it, Billy Bob? Written in Canada's own domestic statutory laws. Inalienable rights, which can never ever be limited or abridged. Canada knows its obligation to the international order, even though they continue to play games and deny our rights. The international order declared the following. The mandate notes that some governments have made efforts to ensure that domestic legislation reflects state obligations contained in the Declaration and other international human rights standards. Notwithstanding some positive developments, the information received by the mandate suggests that the current trend in many countries is to pass laws and regulations restricting the space for human rights activities. Numerous national laws continue to be or have become incompatible with international standards and with the Declaration in particular. While most national constitutions formally guarantee human rights, secondary laws have subsequently restricted rights that are pivotal for the full implementation of the Declaration. In many cases, states have used these domestic laws to legitimize violations of human rights and to seriously impair human rights. The international order has already pronounced accountability upon you, Canada, for what you have been doing. The judiciary in Canada are also aware of their obligations and the duty to respect and ensure that the rule of law be obeyed and that the principles of justice found under this international order must be abided by. R.V. Peel Regional Police Service. The courts, too, must conform to the rule of law. The rule of law is the very foundation of the Charter. It stands to reason, then, that the courts are duty-bound to apply the Charter. The rule of law, however, does more than demand compliance with the law. To validate this demand, the law must provide individuals with meaningful access to independent courts with the power to enforce the law by granting appropriate and effective remedies to those individuals whose rights have been violated. The rule of law not only demands that its declarations be respected, not only demands that men and women be allowed to operate their inalienable rights, but it further demands that if violations by governments are taking place against our natural rights, the court system must provide a remedy and protection against these evil individuals who sit in government offices, because that is what they are, evil, to think and believe that anyone has the power or authority to limit absolute inalienable rights. Well, that is completely illogical and foolish. No one has the right to limit and abridge our individual absolute rights. Yea, but they do it anyways. They do it because they know that most individuals have no capacity to enforce their rights. And by capacity, I do not mean monetary capacity, I mean the knowledge. That is he capacity I am referring to. That capacity is lacking because Billy Bob and the other so-called freedom fighters have pucked around with your capacity by feeding you lies and deceptions about what is truly transpiring with our individual freedoms. The rule of law states that only human beings can enjoy the rights that are articulated and brought forth in the Charter of Rights and Freedoms, Article 7, SCC Thompson Newspapers, Little DEV Canada, at PU Town 4, everyone has the right to life, liberty, and security of the person, serves to underline the human element involved. Only human beings can enjoy these rights. Everyone, then, must be read in light of the rest of the section and defined to exclude corporations and other artificial entities incapable of enjoying life, liberty, or security of the person, and include only human beings. It is clear that the Charter, as acknowledged by the judiciary, recognizes the human being, the natural person, under full legal capacity. This recognition, which aligns with the international order under Article 16 of the ICCPR, must also apply to Article 24 of the Charter. The subject being brought forth is particular in its designation to anyone. Therefore, a human being standing under their natural personhood, under their full legal capacity, is indeed recognized as having access to the remedy brought forth in Article 24, enforcement of guaranteed rights and freedoms. 24.1. Anyone whose rights or freedoms, as guaranteed by this Charter, have been infringed or denied may apply to a court of competent jurisdiction to obtain such remedy as the court considers appropriate and just in the circumstances. Article 24 states, as guaranteed by this Charter, not in this Charter. The specific wording used here indicates that every obligation that Canada has towards rights and freedoms are not all directly contained within the Charter, but are indeed guaranteed by the Charter. All rights and freedoms are not all explicitly expressed therein. That is why the expression used is by. This is expediently confirmed 2 verses later in Article 26 of the Charter. Other rights and freedoms not affected by Charter 26. The guarantee in this Charter of certain rights and freedoms shall not be construed as denying the existence of any other rights or freedoms that exist in Canada. The Charter in Article 26 clearly states that the guarantee in this Charter of certain rights and freedoms, certain indicating a qualified number or a qualified amount. The Charter now gives a legal guarantee that just because certain rights and freedoms were listed in the Charter itself, this is not to be taken or understood as a denial of the existence of any other rights or freedoms that exist in Canada. The Charter declares if there are other rights in Canada, they are operable, and this produces the legal guarantee. ICCPR Article 16, everyone shall have the right to recognition everywhere as a person before the law. Life, liberty, and security of person 7. Everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. The subject in Article 16 of the ICCPR is designated as everyone, a human being, man or woman. The human being has the right to be recognized before the law. This legal recognition is known as the natural person or natural personhood. This article of law states that this recognition is operating as a right. A right is a personal choice involving autonomy and liberty to choose. In this particular principle of justice, the autonomy afforded and the liberty acknowledged is to what recognition they will take before the law. A human being has the right to be recognized before the law under their natural personhood without any additional impositions added to the recognition. Whether an individual stands under Article 7 of the Charter, under the principle of liberty, or whether an individual comes through Article 26 directly into the ICCPR to invoke Article 16, the principle of justice remains the same. The rule of law concerning the right of the man to be recognized in their natural capacity under their full legal capacity is a guarantee, and no derogation can be applied to that right. The right is peremptory, and as such commands a legal obligation. Qualifying the right as being peremptory, the covenant itself does not permit a limitation to be placed upon the right. A peremptory norm of general international law, also called jus cogens, is a legal principle or right that produces a higher and stringent legal obligation upon governments to not interfere with the right. Vienna Convention on the Law of Treaties, Article 53. A peremptory right is non-negotiable, universally binding, and overrides all conflicting laws, domestic or international. Responsibility of states for internationally wrongful acts, 2001. Chapter 3. Serious breaches of obligations under peremptory, Article 40. Application of this chapter. 1. This chapter applies to the international responsibility which is entailed by a serious breach by a state of an obligation arising under a peremptory norm of general international law. 2. A breach of such an obligation is serious if it involves a gross or systematic failure by the responsible state to fulfill the obligation. Article 41. Particular consequences of a serious breach of an obligation under this chapter. 1. States shall cooperate to bring to an end through lawful means any serious breach within the meaning of Article 40. So inalienable rights are absolute natural rights. They exist originally under common law and are never to be limited or abridged. They are considered peremptory and place a much higher level or responsibility upon the government by creating an automatic duty to obey and not limit